Hello. The purpose of this video is to help you learn about mediation, the process, and to get you to be more comfortable and knowledgeable with mediation as a whole. You may have some questions that I wish to address here. First, what is mediation? Mediation is a process whereby a neutral third person acts to encourage and facilitate the resolution of a dispute between two or more parties. It is an informal and non-adversarial process with the objective of helping the disputing parties reach a mutually acceptable and voluntary agreement. In mediation, decision-making authority rests with the parties. The role of the mediator includes, for example, assisting the parties in identifying issues, fostering joint resolution problem solving, and exploring settlement alternatives. Second question, what is a mediator? A mediator is a neutral, impartial, third person who facilitates the mediation process. The mediator's role is to reduce obstacles to communication, assist in identifying issues, explore alternatives, and otherwise facilitate voluntary agreements to resolve disputes without prescribing what the resolution must be. Third, who is allowed to be present for the mediation? The parties to the dispute and their attorneys are allowed to be present during the mediation. Anyone you wish to bring that is not a party to the dispute may be allowed to be present if the other parties or party consent. Fourth, who must be present for the mediation? If it is a court-ordered mediation, someone with settlement authority must be present, either a lawyer with authority to settle or the party themselves. Fifth question is, who pays for mediation and how much does it cost? Mediation through the court in Florida costs $120 per person per scheduled session in the family mediation when the parties' combined income is greater than $50,000 but less than $100,000 per year. It costs $60 per person per scheduled mediation session in family mediation when the parties' combined income is less than $50,000. It costs $60 per person per scheduled session in county court cases. No mediation fees shall be assessed under the statute in residential eviction cases against a party found to be indigent or for any small claims actions. Next question is 6. Are there different kinds of mediation and what are they? Yes, there are different kinds of mediation. First, there's appellate court mediation, which means mediation that occurs during the pendency of an appeal of a civil case. There's also circuit court mediation, which means mediation of civil cases other than family matters in circuit court. If a party is represented by counsel, the counsel of record must appear unless stipulated by the parties or otherwise ordered by the court. The next kind of mediation is county court mediation, which means mediation of civil cases within the jurisdiction of the county courts, including small claims. The next kind is family mediation, which means mediation of family matters including married and unmarried persons before and after judgments involving dissolution of marriage, property division, shared or sole parental responsibility, or child support, custody, and visitation involving emotional or financial considerations, not usually present in other civil cases. The next kind of mediation is dependency or in need of services mediation, which means mediation of dependency, child in need services, or family in need services. The next question you may have is what to expect during the mediation process itself. The mediator will usually bring all the parties into a room. Most mediators choose to sit at the head of the table. The mediator will usually begin by introducing themselves and reciting a short opening statement. An opening statement will usually sound something like this. Good afternoon, my name is such and such. I am a Florida Supreme Court County Mediator. They'll explain what the mediation process is. Mediation is a consensual process. I, as the mediator, am a neutral, impartial facilitator. I'm not a judge and have no authority to tell you what to do or to make you do something that you are not comfortable with. They'll talk about how the process is confidential. They'll maybe lay some ground rules about, treating everybody with respect or not interrupting. They might say something about a caucus. They'll explain that during the mediation, they may choose to meet with each party individually, and what is said during that individual session remains confidential toward the other party unless said that that what is said is not confidential, which would be the party's decision to waive that. They might discuss something about a mediated settlement agreement, that if you choose to settle the agreement, there will be a writing that you will both agree to and sign. They may ask if you have any other questions. After the opening statement, a mediator may ask each side to explain what brought them to the process, because oftentimes the mediator doesn't have any background information as to why what the dispute is that's being mediated. It is important during the mediation process that you give the other side an opportunity to talk and for them to give you the same respect. If you have anything you wish to say, you can write it down and we can make sure that anything that you have to be said will be heard. The next question you may have is, what are the possible outcomes of a mediation? The possible outcomes are either settlement, where you agree to settle the case on terms that you wish to have. There can be something called an impasse, which is when the parties do not agree to and cannot reach an agreement. And last, there's termination of the mediation, which is when, for one reason or another, the mediator may decide to terminate, to end the mediation process. The next question is, what is confidential during mediation? What is said or communicated in mediation is confidential. That means no one can repeat what you said in mediation, and you cannot say what someone else did or said during mediation. However, there are some exceptions. Abuse of children or vulnerable adults must be reported. Other exceptions include, but are not limited to, if the communication is in pursuit of a crime or criminal activity, or if the communication is being offered to prove professional misconduct, such as mediator misconduct or the attorney misconduct. 10th, what are some things to keep in mind during the mediation process? Be respectful of all parties. It is hard to undo something that's said during mediation, and mediation works better if everybody treats each other with respect in an open and honest form. There are things besides money that may be advantageous to you, so try and have an open mind during the process. Ultimately, you are the decision maker. We will only settle if you want to settle and feel comfortable with the outcome. If you are tired or choose to leave the mediation, that is your decision. Try and keep in mind the benefit of mediation is that you are in control and not the court. Mediation can save you a lot of time and money and future hard feelings, so try and keep an open mind during the process. Ultimately, this mediation is only to benefit you. Like I said, if there's any time you wish to leave or end the mediation, that is absolutely your decision. And if you reach to come to a settlement agreement, that too is your decision. I am absolutely here to answer any further questions you have or anything that you might need clarification on. But thank you again for taking the time to watch this short video on what mediation is and what you can expect during a mediation process. Thank you.